Shareholder Services Limited.
Yes, Mr. Barry.
If it pleases your lordships, I appear for the defendant appellant in this matter. My learned friend Mr. Latham
Yes.
appears for the claimant respondent. As your lordships will be aware, this is my client's appeal against the decision of Her Honour Judge Ingram of the 10th of February of last year, whereby she rejected my client's appeal against the decision of the district judge in January of 2019, firstly on a provisional assessment on paper, and then in May of 2019 by way of oral hearing, those decisions being to the effect that the claimant's costs in this low-value employer's liability personal injury case are not subject to the fixed recoverable cost regime that would otherwise apply, and the reason it was held that they were not was by virtue of the terms of a consent order.
I hope it helps you to know, Mr. Marinew, we've read the judgments, we've read the skeleton arguments, and we've dipped into the authorities. In particular, we've had a good look at Ho.
Lord, I'm very grateful. That is indeed helpful. I will take your lordships in due order, and I hope in relatively short order in light of that indication. Firstly, to the applicable rules, and then following that directly to the authorities, and in particular, I will be focusing on three of the authorities: the case of Sharp, the case of Hislop, and the case of Ho or Adelaken, whichever. I'll try and refer to it as Ho, but I sometimes slip into Adelaken instead. But my lords, before I do, as your lordships will also be aware, permission to appeal in this case was granted by my Lord Justice Stuart Smith on the 12th of October of last year. And if I may just briefly refer to the reasons he gave for permission to appeal, my Lord, before I do so, I should ensure that we have all the necessary bundles.
Well, I've certainly seen his reasons in my reading.
I hope your lordships.
I think it's in the core bundle.
It is, my lord, and it's at page 75 of that core bundle. There should be a core bundle, a supplementary bundle, and then an authorities bundle. That's as far as we've got all that. Stretch.
And we've got, I think, loose. I've got your replacement skeletons.
I'm grateful, my lord. So, my lord, if we could just briefly turn to page 75 in the core bundle. So these are the reasons given by Lord Justice Stuart Smith. The first simply deals with the point about prospects of success, an important point of principle, the second appellate test, and the core of the appeal. But if I can just direct the lordship's attention briefly to the second, despite the apparent strength of the decision in Ho, further clarification may be required in order to restore certainty in an important and extensive area of litigation. And before turning to the rules and the authorities, may I try your lordship's patience by just for a few moments perhaps explaining why we're here, because I fully appreciate that this court's time is not, and frankly should not, normally be taken up by dealing with satellite cost disputes involving low-value personal injury cases.
Well, low-value cases are just as important a part of this court's jurisdiction as high-value cases. Well, so you don't need to apologise for that.
My lord, I fully appreciate that, but of course one of the very purposes of the fixed recoverable cost regime is to avoid satellite cost disputes. And therefore, if it works, we shouldn't be finding ourselves troubling this court, as unfortunately this court has been troubled on quite a number of occasions, both generally in relation to the operation of the rules, but also at least now on 3 occasions, by this question of parties contracting out or potentially contracting out of those rules. And so if I may, just for a moment, as we will see, my lords, I hope to establish in front of this court that the way the fixed recoverable cost rules are intended to work is that parties who have cases which fall within the scope of those rules should always anticipate and understand that all they will recover in such cases are fixed recoverable costs, save in 2 circumstances. And the first circumstance is where those rules themselves, or a directly related rule such as Part 36, expressly provide, and I emphasise the expressly, for a different consequence. The second, which has been acknowledged by this court on 2 occasions before, is where the parties agree that there should be a different outcome other than fixed costs. And whilst, of course, seeking to persuade your lordships in relation to the individual facts of this case that my client's position is right, we would not be here were it not for the fact that we consider this point is of wider relevance. And we seek, in front of this court, for this court to restore that certainty that the Lord Justice Stuart Smith refers to in granting permission to appeal, by making clear that if parties wish to contract out of fixed recoverable costs, they must do so clearly and expressly, just as if the parties want to rely on an exception to fixed recoverable costs, that must be a clear and express exception in the rules.
But we can't override very clear Supreme Court authority as to how you construe an agreement. And what can we say that would override the chart book, the law, that one has to construe an agreement looking at its express terms and the context?
My lord, of course, and I don't invite you to do so. It would be a bold submission for me to seek to do so, a bold and misguided submission.
Well, every agreement in that case has to be looked at on its own terms to see whether, in the context, which you rightly say is fixed costs are the starting point in certain situations, but here we're all agreed that there was an agreement which has to be construed.
My lord, absolutely. The fundamental point that I will seek to emphasise to this court today is that point of the context. I absolutely agree, of course, that we're not here to seek to subvert or recast the rules as to contractual construction.
Well, may I say, for my part, your written argument, is very comprehensive and heavy on context. It is almost completely lacking in any consideration of the words used and what they mean.
Well, my lord, if that's correct, I'll hope to correct that deficiency, because the key words here are detailed assessment within this. That is what the judge below relied on. That is the aspect which...
Well, the words are costs subject to
Indeed.
A detailed assessment.
Lord, yes.
A term which is defined in the rules.
Yes, my lord, and I'll endeavour to show, firstly by reference to both the rules and the authorities, that detailed assessment in that context, firstly in the context of this individual case, was put forward, we say, looked at objectively, is being used as a process which is not inconsistent with the fact that the costs would otherwise be fixed. So the costs are fixed, but there is provision for a process in the event of any dispute, and that process is detailed assessment. And as this court has identified previously, or accepted, because it wasn't disputed between the counsel and the case, where there are fixed costs, a detailed assessment may take place. It may be that there are aspects of the costs which still fall to be assessed, and the process that will be used is detailed assessment. So in that context, and in the context of this specific case, there is nothing in the use of the term cost subject to detailed assessment which we say would be sufficient to oust the wider context, and this is the part that I seek to emphasise, the wider context, which is both the nature of the rules and the policy behind them, and also what this court has repeatedly identified as the point, which is that parties should have an expectation in such cases that fixed costs is all that they will get. And that is a fundamental part of the context. And as I hope, Lord, if it wasn't clear from my skeleton argument, I hope it's at least covered by the grounds of appeal. That is one of the fundamental aspects that we sort of say the judges below failed to attach proper weight to, which is that wider context. So, my Lord, as I say, and I'll turn then to the rules and the practice direction in just a second, but we do invite this court not to recast the rules on construction, but to lay the appropriate emphasis on the context of cases of this kind when considering what parties must do to satisfy those rules of construction in terms of the reasonable observer with knowledge of the factual matrix reaching the conclusion as to what the objective construction of the terms of that agreement is. So, My Lord, may I then take you just very briefly to the rules? They are set out either in the White Book or they are also referred to, if it assists, if it's a shorthand to get there. The relevance extracts are set out in the case of Sharp, and it may be that for present purposes I can simply direct your Lordship.
So that's tab 8 in your authorities book.
My Lord, it is. And if your Lordships would be kind enough to come on within Sharp, and I'll deal with the Sharp case comprehensively at this point, but if I can start just with the relevant rules. The Sharp case, it was an ELPL protocol case, so a case that had started in the protocol but had fallen out. So for practical purposes and procedural purposes into this one. The relevant rules are at page 149 within the bundle, starting at paragraph 15. And so, as my Lord Justice Briggs, as he then was, said at paragraph 15, for present purposes, the relevant provisions of Part 3A of Part 45 are as follows. And so 4529A sets the scope, and there is no doubt here in this case, as in the Sharp case, that this was a case that was within scope. It was what's described as an ex-protocol case. So it's a case that had started in the protocol, but because as is provided for in the protocol, there hadn't been an admission of liability within the necessary 30 days, it fell out of the protocol. Ex-protocol cases remain subject to fixed costs, and so that's dealt with in 45 section 3A, and then we have 4529A, which indicates that scope. We then come to 4529D, application of fixed costs and disbursements, subject to 3 identified rules which are part of the exceptions. In a claim started under the protocol, the only costs allowed are fixed costs in Rule 4529E, so that's fixed profit costs in effect, and disbursements in accordance with Rule 4529I. And we can come to look at the disbursements if we need to, but in short, in these cases, some of the disbursements are either fixed or limited in their sum, and others are at large. So there are identified categories of disbursements. If it falls within the category, you can recover it, but the sum is an issue that, if disputed, would have to be quantified by the court. There are then, as indicated at paragraph 16, tables provided for the purposes of the calculation of the fixed profit costs. And again, Lords, we can turn those up if we need to, but in short, the way those tables work is they work on a combination of settlement value and period. So there are stages throughout the life of the case, and if the case reaches a particular stage, the costs go up, and the amount of the cost is calculated by reference to a percentage of the settled damages value plus a fixed sum. And the combination of the two takes you to, it is a purely arithmetical application of the table. There's no discretion involved to get to the appropriate figure for fixed costs. So, my Lord, those are the key applicable rules, and as your Lordship will be aware, although the rules are slightly different, 4529D is repeated in essentially identical terms in 4529B for road traffic accident protocol cases. That is the key point, that the only costs allowed are the items specified there. And so that is the core starting point. If we come back up to paragraph 14, we can see what Lord Justice Briggs tells us about the comprehensive nature of this section of Part 45, and he refers there to the small number of limited exclusions and exceptions from the applicability of the regime, and he notes that these exclusions were all expressly made.
I'm very sorry, I lost the paragraph.
Apologies, my Lord. Paragraph 14.
14.
So that starts with Section 3A of Part 45, providing almost as comprehensively for fixed recoverable costs, but no longer continued under them. So those are the ex-protocol claims. And the only reason he says almost as comprehensively as he explains is because whilst the exceptions were expressed, there was one which wasn't. So he says, with one exception, those exclusions were all expressly made. And that was the one that had been identified by his lordship and the Court of Appeal in the case of Cada that he refers to, which was where a case is allocated to the multi-track. And what had happened in Cada, as he notes there, was that that exception should have been in the rules but wasn't because of a drafting error. And so the rules were amended. So all of the exceptions are express within the rules. There are no implied exceptions. It's a comprehensive scheme. And then, my lords, if I can invite you to come on to page 152, paragraph 31. And this is part of what we say is key to the matrix, the context, when construing any agreement for the payment of costs. The starting point is that the plain object and intent of the regime in relation to claims of this kind is that from the moment of entry into the portal, recovery of costs of pursuing or defending that claim at all subsequent stages is intended to be limited to the fixed rates of recoverable costs, subject only to a very small category of clearly stated exceptions. And then he notes that to recognise implied exceptions in relation to such claim-related activity and expenditure would be destructive of the clear purpose of the fixed cost regime, which is to pursue the elusive object of proportionality in the conduct of small or relatively modest types of claims to which that regime currently applies. And my lord, we say that the same principle applies in relation to the question of contracting out. It is an important part of the background and the matrix that everybody should start with the expectation in these cases that only fixed costs apply.
Unless they agree otherwise.
Unless they agree otherwise, of course, my lord, absolutely.
So, forgive me,
No.
I really struggle where there is a clear express exception that you can agree otherwise. The only thing that the court has to consider is construing this agreement, have the parties agreed otherwise. And if you start from the assumption that they must start and end with the expectation, then you're completely removing the freedom which the rules have expressly given to the parties, particularly when represented by solicitors, to so do.
Well, my lord, I hope not. What I'm seeking to do is indicate that it is important to recognise that these cases, there are literally hundreds of thousands of these sorts of cases every year. They're dealt with by relatively junior fee earners. That's the nature of these cases. It couldn't be otherwise on both sides because they are low-value fixed cost cases. And the solicitors, albeit, as you say, my lord, the assumption is parties have solicitors. The solicitors on both sides are expected to work on the assumption that these are fixed cost cases.
But they're solicitors. I mean, what you're saying, almost saying to, inviting us to say, is that, well, if solicitors are sloppy in their dealings with orders, they will be excused the sloppiness because the court will not interpret what they've said according to the usual rules of reading what the words say in court orders and interpreting them in that way.
My lord, again, my lord, if that's what your lordship has taken from my skeleton argument, then that's my mistake, because that is not what we are seeking to invite the court to do. What we're seeking to invite the court to do is to say, when considering objectively whether this is what parties have done, a fundamental aspect is that those parties should be assumed.
The context is a very strict, rigid rule
Lord, yes.
of fixed costs, which the parties will really struggle to get out of that regime. As you've set out, parties often try and do so, but the court will strictly keep them within the four corners of that regime. But there is an exception if the parties choose to contract otherwise, and we nearly always recognise in almost every situation that parties properly advised and properly represented have a freedom of contract.
Lord, yes.
And you can spend as long as you like persuading us of how the context is very favourable to fixed costs, but at the end of the day, I do not see the choice we have but to undertake the usual exercise of construing the words of action the parties have actually used in the order You're not seeking to. You've not gone back to try and have it corrected under the slip rule. You've not seek to have it rectified. We have the words the parties use, and we have to construe them.
My Lord, yes, and again, if your Lordship has taken it from it, then I'm inviting your Lordships to do anything other than construe the order according to established principles. That is not our case.
It's not your case, then, that this context that you've outlined to us in some way affects the approach to construction.
My Lord, no, but it is part of the context that is material. So it doesn't affect the principle of construction, but it is part of the factual matrix that goes to the consideration of that construction. The courts have made it, this court has made it absolutely clear that in such cases, the expectation that everybody should be working under is all you are going to get is fixed costs.
Well, unless you agree otherwise.
Unless you agree otherwise, my Lord.
Which we always come back to.
My Lord, we do. And I fully intend to come to the words. It's no part of mine to try and avoid the words at all, because what I seek to do is put, again...
So if the parties had put in capitals, underlined in red, fixed costs do not apply.
Absolutely. There would be no issue.
Yes. With a red hand.
With a red hand.
Well, I'm not sure we would need the red hand, my Lord,
yes.
but
then the next stage is it's not in capitals. It's not. It says it's not in capitals, and we gradually go down and down and down until we just simply have the current words.
Yes, my Lord.
We have to decide what they mean, don't we?
We do.
And do you say here there was a mistake?
My Lord, no.
No mistake.
I have, in that sense, I have no issue with the words. It's no part of our case to say that this was a mistake. It's part of it. Our case is that properly construed, objectively, and again, I appreciate this. This is a word that may encourage the court eventually to tell me to stop using it, but against the context, including the general context of the fixed cost, we say these words do not objectively amount to a contracting out of fixed cost. That's our case. So, Lord, it's not a mistake. It's not seeking to change the rules of construction.
I think it may be what I think. For my part, I'm struggling with is I understand the context.
Lord, yes.
You set it out very clearly. It's very obvious. And in Ho, that led that context, which is that it was acceptance of Part 36, led this court to say that possibly even clearer words, standard costs, actually meant fixed costs. Standard costs subject to a detailed assessment.
Lord, yes.
Question is, in this case, is that still the case, or is it different?
My Lord, absolutely. My Lord, just in terms of Adelaken, and I'll take your lordships to Adelaken shortly, but just to be clear, because I wouldn't want it to be said I misled the court. In Adelaken, of course, the word standard basis came in the order, which wasn't said by either side to actually change the outcome. So, in fact, the words the court was construing in that case were cost subject to detailed assessment. It could have been argued by the claimant that standard basis was an argument in their favour to show that it wasn't fixed costs, but in fact, as the Lord Justice Newing, Lord Justice Mayles made clear, the claimant in that case wasn't relying on those additional words. So I wouldn't want it thought that I misled the court by suggesting that Adelaken set some higher standard. So, my Lord, I'll come to Adelaken in a moment. My Lord, it's plainly obvious that your lordships have considered the authorities and the context. May I therefore skip relatively lightly over them, but whilst not necessarily entirely abandoning the references, simply to indicate to your lordships that the paragraphs of the relevant authorities I rely on.
Yes.
I appreciate your lordships have it from the skeleton argument, but nevertheless, just to make clear the paragraphs I rely on in support of my point.
So where do we go to first?
Before you do that,
of course.
I thought you were going to take us to the relevant rules.
My Lord, insofar as the fixed cost rules were there, I've taken your lordship to the key rule, and if I can emphasise it, I can take, if it's easier, my Lord, if your lordship has a white book, I can take your lordship to the rules in the white book if that would be easier. But the key rule, if we come back for present purposes, my Lord, to page 149.
You mean we're still in sharp?
We're still in sharp, my Lord.
Okay.
Yeah.
If we come back to page 149, paragraph 15, the two key points to draw from the rules are, the first question is, question number one, is this case a case within scope of the fixed cost rules of 45.3a? For my Lord, Lord Justice Baker's benefit, the rules are pages 1558 of
Thank
the
you.
White Book. We follow them through in the White Book. If your Lordships would be kind enough to come back to 1555, your Lordships have there the heading in the middle of that page, claims which no longer continue under the, I'll use the shorthand, protocol. And then we have 4529A, which was the rule that's set out in paragraph 15 of Sharp, which deals with scope. So what cases fall within this? And your Lordships will see that it covers both ex-protocol RTA claims, little 1, and ex-protocol EL and PL claims. This was an EL claim in little 2, where such a claim no longer continues under the relevant protocol. So this is a case, there is no dispute about this. This is a case that is in scope.
Sorry, forgive me. I assume that you would be showing us the rules about detailed assessment.
Well, I'll take you to the rules about detailed assessment in a moment. I can do that now if your Lordships are content that you have everything you need in relation to the fixed cost rules. Just to complete that very briefly, the key relevant rule is 4529D, which is page 1558. And so this is the paragraph that's dealt with by the Lord Justice Briggs in the Sharp case. So subject to the 3 identified rule-based exceptions, 4529F, 4529H and 4529J, and for as long as the case is not allocated to the multi-track. So that is the exception that the Court of Appeal had identified in CADA, which wasn't in the rules but was written in after the CADA case. So it should have been there in the first place. So for as long as the case isn't allocated to the multi-track. In a claim started under the protocols, the only costs allowed are fixed costs, 4529E, and disbursements. And since we're down all over the page, you have on page 1559 the table that I referred to, which gives you the arithmetical calculations of the fixed costs. And just for your Lordship's benefit, since we're there, the one that would have applied if fixed costs applied in this case is the very right-hand column in table B. Your Lordship sees where a case settles on or after the date of listing but prior to the date of trial. Total of 4,280 plus 30% of the damages. So those would have been fixed profit costs. And to complete the short guided tour, if your Lordships come to page 1563, this is disbursements. So we've seen how profit costs are calculated under disbursements, 4529I, subject to the following paragraphs. The court may allow a claim for a disbursement of a type mentioned in these paragraphs, but will not allow a claim for any other type of disbursement. And so the way it works with disbursements, my Lord, is apart from in RTA cases, which are dealt with under 2A, where some of the costs are fixed. Generally speaking, for disbursements under little 2, under paragraph 2, the way it works is that you can have certain categories of disbursements, but the amounts are not fixed, and if there is a dispute, have to be quantified by the court.
So my Lord asked you about other rules. Are you going to refer to?
My Lord, yes. In terms of other rules, may I start by taking your Lordships to CPR 44.3 and then CPR 44.4, which deal with the assessment of costs. And 44.3 is page 1479, my Lord.
Thank you.
So 44.3 deals with where the court is assessing the amount of... Sorry, my Lord.
But don't you have to start at 44.1, where it defines detailed assessment?
my Lord, I'm obviously content to do so, and if it assists the court. So, my Lord, as your Lordship sees, page 1441, detailed assessment is a procedure by which the amount of cost is decided by a cost officer. A cost officer includes a costs judge. And we can see that in the immediately preceding paragraph, or a district judge. So 44.2 deals with the discretion in terms of awarding cost, which isn't, as I'm material to the present situation. And 44.3, which is page 1479, deals with the basis of assessment. So where the court is to assess the amount of costs, it will assess those costs on the standard basis or the indemnity basis, but will not in either case allow costs which have been unreasonably incurred or are unreasonable in amount. And then just within that, at 44.3.5, there are a set of factors given to assist the court in deciding whether costs are proportionate. And then more generally, proportionality aside, at 44.4 on page 1489, are the factors given to assist the court in deciding whether the costs are reasonable. So, and that encompasses both under 44.41, essentially deciding where the benefit of the doubt lies. So the key difference, as this court will know, between standard and indemnity basis is on the standard basis the benefit of the doubt goes to the paying party. On the indemnity basis, the benefit of the doubt goes to the receiving party. And then at 44.4.3 are a list of factors that the court is also to have regard to in deciding the amount of the costs. So detailed assessment, Lord, is a process for deciding the amount of costs. And
well, we have a whole part dealing with it, don't we?
We do. Part 47, Lord, yes. Part 47 deals with, so Part 44 deals with the principle of the factors that the court must apply, and Part 47, which starts on page 1632, deals with the procedure. So, for example, it deals with how soon after you have a costs order or a deemed costs order in your favour or an agreement, you must commence your assessment proceedings. The venue, how you do it by way of producing a bill of costs, all of those matters. And there's an extensive practice direction which deals with the detail of such matters.
Well, I think this is important though, isn't it? Because a bill of costs is completely inconsistent with fixed costs.
Well, my lord, in my respectful submission, it's not, because within a case where fixed costs are awarded, there is always the potential for a dispute as to the quantum of some of those costs. And if there is a dispute as to the quantum of some of those costs, the process which will be adopted for resolving that dispute is likely to be the process of detailed assessment.
Which costs may be the subject of dispute? Is it just disbursements?
It would be the disbursements, my lord, yes.
So, and disbursements are 4529I.
Lord, yes.
And the court may allow a claim under certain heads A to H in subparagraph 2. What is the process called by which that exercise is carried out?
Well, my lord, the likely process would be detailed assessment. There is no other process for resolving that dispute identified within the rules. And if I may take the lordships to the case of Adelaken, the Hoe case, which is in your...
Have we now finished your traverse of the rules?
Subject to any questions from.
Do you want to take us to 3613, which is features in the case?
My Lord, it does. I was going to take your lordships to 3613 through what this court has said about it in the case of Hislop, but I'm content to take your lordship directly to
Well,
it.
would you mind if we did it to 1284 in my copy of the White Book?
So, my Lord, the important point about 3613, which, as your lordship has indicated, is at page 1284. I'm grateful to your lordship. So, the fundamental point, and this was the subject of the dispute in Hislop, is that 3613 in essence does not stand alone. Where the case is one to which fixed recoverable costs would apply, 3613 is essentially a signpost en route to 3620, which provides for fixed costs, and we can see that within it. So, subject to paragraphs 2 and 4, and to Rule 3620, and that's the important point. Where a Part 36 offer is accepted within the relevant period, the claimant will be entitled to the costs of proceedings up to the date on which notice of acceptance was served. And then the parentheses note what 3620 provides, but in fact we have 3620 itself. If we come on to page 1300, so 3620 provides that this rule applies in essence to X protocol claims A and B. Where a Part 36 offer is accepted within the relevant period, the claimant is entitled to the fixed costs in Table 6B, C or D. And that, of course, Table 6B, C or D only deals with the profit costs. So the claimant will have an entitlement to disbursements.
The reference in the case, in this case, to 3613 is to 3613(4)A, isn't it?
My Lord, yes. And so the content, coming back to page 1284, the particular material context of this individual case is that there is a reference, and I'll take your lordship to the documents, I'm sure your lordships have seen them, in this particular case, to the reason why the claimant asks for a consent order to be completed. And that is because the Part 36 offer has been made at a period which was less than 21 days before the start of a trial. And if that's correct, the principle of liability for costs must either be agreed between the parties or determined by the court. So, and that is 3613(4), which is at the bottom of that page, 4A. We don't need to worry about 4B and C over at the top of the page, but then the relevant part continues 5 lines down at the top of page 1285. The liability for costs must be determined by the court unless the parties have agreed the cost.
Now, you emphasised the word liability. Why?
I do, my lord, because it's important to understand what is being considered here. The reason for this is that if you have an offer which is made late, it may be that there are arguments that follow, because it's akin to, as we will see, under B and C. So what this rule is dealing with is circumstances where there may be an offer which is made, which is going to be accepted, but there may be scope for argument about the principle of those costs. In other words, whether for some reason it should not automatically follow that X pays Y's costs. And therefore, the reference that is used is the liability for costs must be determined or agreed.
Well, liability includes quantum, doesn't it?
Well, my lord,
in that context?
In my submission, no. What it's dealing with there is the question of who's agreeing to pay whose costs and for what period.
And in what sum?
Well, my lord, in what sum would inevitably follow if the sum's not agreed? But the purpose of 3613(4) is to deal with the question of any potential argument as to who's paying whose costs and for what period.
The reference, well, no doubt we'll come on to the specific reference to 3613(4)A in due course.
Lord, no doubt we will come back to it when we come to consider the specific documents. My lord, just to be clear, I'm not saying that, of course, at that point a party could not say, we also want to open the question of whether the costs are fixed or not. Just like, for example, when even if 36.13.4 didn't apply, you just had a costs order automatically or agreed. Of course, the parties can then say, in terms of the quantum, well, we want to contend that the fixed costs shouldn't apply. We accept we'll pay your costs for that period, but only on the basis that it is fixed cost or it isn't fixed cost. But the purpose of 36.13.4 is to address questions of liability for costs, not, per se, quantification. My Lord, just responding again, if I can come back, if I may, to the Lord Justice Edis's question in relation to the procedure, if there is a dispute in relation to disbursements and which procedure applies. And I was going to take your Lordships, unless your Lordships have any further questions arising specifically from the rules in the White Book, if I can take your Lordships to the Hoe case, and that is in the supplemental bundle starting on page 2. Lord, there are a number of aspects of this, but just to deal with, firstly, a very brief introduction to the case. Your Lordships have read it, so won't need much, if any, but then to take your Lordships to the point that's directly related to my Lord Justice Edis's question. So this was a case, as your Lordships will have seen, the facts are dealt with paragraph 3, page 5 onwards. This was a case, an RTA ex protocol case, in fact, where it was an offer by the defendant. So it was a defendant's offer at the bottom of page 5, and the defendant included within that offer at the top of page 6, paragraph 3 of the offer letter, the term, if accepted within 21 days, our client will pay your client's legal costs in accordance with Part 36, Rule 13, such costs to be detailed assessment if not agreed, subject to detailed assessment if not agreed. And just pausing there were essentially two aspects to the claimant's argument in that case, which were to be taken cumulatively or separately. The first was that the reference to 36.13 was to be taken to be an acceptance of standard basis costs. And that was rejected for the reasons that we've just seen, which is that 36.13 in such cases is no more than a signpost to 36.20. And the second was that the reference to cost to be subject to detailed assessment if not agreed, objectively construed, was to be taken to be an agreement to contract out of fixed recoverable costs. And just for my Lordship's benefit, your Lordship has at paragraph 6 of that judgment, in the latter sentences of paragraph 6, the reference to the consent order which provided for reasonable costs on the standard basis to be subject to detailed assessment. But as your Lordship will see, and probably I'm sure has already seen, it was agreed in fact before the Court of Appeal that the agreement had been arrived at by acceptance of the Part 36 offer, and therefore the terms of the consent order, which came subsequent to that agreement which had been arrived at, could not affect the construction of the agreement. And so therefore the reference to standard basis was not in fact material to the Court of Appeal's determination. Lord, coming then to the point about process, if I can invite your Lordships on to page 12 in the bundle, paragraph 19 of the judgment of the Lord Justice Newey. So here the court was considering the question of process and assessment. And so what was noted there was that CPR Part 45 does not itself explain how the amount recoverable in respect of disbursements under 4529I is to be determined, but it was common ground between counsel that the provisions relating to detailed assessment found in CPR 47 would apply. Then Mr. Roy, who was for the defendant, so he was the one seeking to argue that it was fixed costs only, illustrated the point by reference to another case of this court, a case called Aldred and Cham, a decision of the Lord Justice Coulson, the leading judgment. That case involved an issue as to whether a fee in respect of advice from counsel was within the fixed cost regime. And as can be seen from paragraphs 8 and 9 of the judgment of Lord Justice Coulson, the matter was subject first of a provisional assessment and then an oral assessment in accordance with 4715. 4715, my Lord, is a subset of the rules on detailed assessment which apply to claims where the costs claimed are less than £75,000. So it is a part of detailed assessment, but it's a subset that applies in low value costs claims. And so, whilst it was not a bone of contention before the court in Adelaiken because it was accepted, the provisions of detailed assessment do potentially apply in a fixed recoverable cost case because not all of the costs are fixed. And where some of those costs are fixed, there has to be a mechanism for resolving disputes. And the only mechanism to be found under the rules in relation to costs for resolving disputes where there is a dispute as to the amount of the costs is detailed assessment. And my Lord, that comes right back, without wishing to go too much round in circles, but that of course comes right back to the definition of detailed assessment that your Lordship took me to earlier, which is that detailed assessment, apologies, CPR 44.1, that's the reference, Lordship will just take a moment. That detailed assessment is the procedure by which the amount of costs is decided. And so it has been recognised by this court previously, it would appear on 2 occasions, that detailed assessment as a process is not inimical to the concept of fixed recoverable costs. And if I may try and assist your Lordships by just carrying out a sort of, to try and assist in response to this question, a sort of analysis of how this might work in practice. If we have a case which is prima facie a fixed recoverable cost case, but as we know, not all of those costs may be fixed, where the parties cannot agree on the amount of those costs, and sometimes they can't agree because it might be something to do with the fixed costs themselves. It might be they can't agree which of the stages the case finished in, which of the boxes. It should be simple, but because of the hundreds of thousands of these cases, there are always disputes. Or it might be a case as to the disbursements. But if the parties can't agree the amount of the cost, the only process identified for them to resolve that is detailed assessment. Now, within that detailed assessment, the first question the court would ask itself is there an element of these costs which the rules fix? And the answer with profit costs ordinarily would be yes. So that makes that process, there's no need to assess the profit costs because the rules are fixed. The court would then say, well, what isn't fixed? Well, it's the disbursements. And then, Lord, when considering those disbursements, again, to emphasise the point that the usual procedure would apply, how would the court decide? It knows what disbursements can be allowed, but if the dispute is as to the quantum of those disbursements, how would the court decide what the quantum of those disbursements is? Well, Lord, the only rules that tell the court how to decide what the quantum of those disbursements are CPRs 44.3 and 44.4, which tell the court what factors to take into account in deciding whether the costs are reasonable. So whether it's because there's a dispute as to the precise mechanical quantification of the fixed recoverable profit costs, or whether it's because there's a dispute as to the amount of the disbursements, or whether they're within the list of recoverable disbursements, there are all sorts of arguments, I'm afraid, in these cases. There's a current running argument about where solicitors instruct agents to produce medical reports, whether the agent's fees can be recoverable as one of the disbursements. That's an argument that is occupying, sadly, district judges left, right and centre at the moment. But it's an argument that will be resolved within the context of a detailed assessment, because there's no other process. So, my Lord, the point I seek to emphasise is that whilst assessed costs are different to fixed costs, in the sense that if you have an assessment of the profit cost, you will arrive at a different figure than the fixed cost, the process of assessment in the purpose that it's identified for under the civil procedure rules as being the mechanics by which an amount of cost is decided where there's a dispute is not. because you will quite commonly have cases where the costs are fixed in part, but where if there is a dispute, the parties use the detailed assessment procedure to resolve that dispute. And since, my lords, I appreciate that this is a subject that appears to be troubling your lordships, and I hope I understand why, may I, without going off too far on a tangent, give your lordships another example of why fixed costs and detailed assessment are not incompatible. Detailed assessment as a procedure is not incompatible with the idea that some or all of the costs are fixed. As your lordships may be aware, I appreciate it's probably an awful long time, if ever, since your lordships have trouble with a fast-track trial, but fast-track trial costs themselves, the costs of actually the trial, are fixed. So in a if we forget about the protocol for a moment, and if we just assume a non-protocol case where the other costs aren't fixed, but it's a case that goes to the fast track. In a case in the fast track, you'd get to the end of the case, say it settles before trial, you get an order that defendant pay claimant's costs to be assessed. Might say even to be assessed on the standard basis subject to detailed assessment. But if your lordships would be kind enough to go on to page 1571,
in the white book.
in the white book, my lord, there is an element of those costs that the rules would fix. And on page 1571, we have rule 4537. This section deals with the amount of costs which the court may award as the cost of an advocate for preparing for and appearing at the trial of a claim in the fast track. So the rest of the costs in that case wouldn't be fixed. But there is a specific rule, and if we follow that rule over, and it's only dealing with essentially advocates' fees for the trial, if we follow that rule over onto page 1572, we come to 4538. Table 9 shows the amount of the fast-track trial costs which the court may award by summary or detailed assessment. So this is an award of fixed costs by summary or detailed assessment. And that sum, under paragraph 2, is a fixed sum. The court may not award more or less. It's not a cap. It's an actual fixed sum. So again, here you have an example of a process where if there's a dispute about the costs of the claim generally, even though some part of those costs is fixed, the process that will be used is the assessment process. But question number 1 that the court would ask itself in that assessment process is, do the rules fix part of these costs? And in the fast-track trial case, the answer would be yes. The fact that the court's carrying out a detailed assessment wouldn't permit of an argument to say, well, actually, those fast-track trial costs aren't fixed because this is a detailed assessment, therefore nothing can be fixed. It simply admits of the fact that part of the costs are fixed, but there is a process by which any residual dispute about the other costs may be determined, or indeed about the application of the fixed costs, or about, for example, you could bizarrely enough end up with an argument about what the value of the claim was, therefore which of the fixed costs heads applied. Never underestimate the power of the parties in cases of this kind to find arguments about all sorts of aspects. But the court would apply the fixed cost to those parts that are fixed and would carry out a detailed assessment of the parts that weren't fixed. And the process would be detailed assessment or summary assessment at the end of the fast-track trial. And so, my lord, the key point that because I fully appreciate that I will be taxed, whether it's by my learned friend or by this court, with the reference in the case of Broadhurst by this case to the idea that assessed costs and fixed costs are conceptually different. But my lord, the point I want to draw is the distinction between process and quantification. Yes, if within the quantification some of the costs are fixed, that is going to lead to a different result to where the costs are being assessed. But the fact that the process used for dealing with any dispute about that is detailed assessment doesn't tell you that the costs are fixed or not fixed. The rules tell you that the costs are fixed or not fixed.
Now, have you finished with the case of Hoe?
Well, my lord, the case of Hoe is, in my respectful submission, likely to be central to this court's determination. So if I may just take a moment just to to endeavour to assist the court with a number of points from Hope. So, my Lord, your Lordships have seen the factual background.
Well,
again,
can we just? I've got the head note in front of me,
of course.
and the offer in that case, as summarised the head note, is it sufficient, or do we need to look beyond that?
My Lord, no, we don't.
So the offer was cost to be paid 30,000 full and final settlement, with cost to be paid, quotes, in accordance with Part 36, Rule 13, such cost to be subject to detailed assessment if not agreed.
Correct, my Lord, yes.
Yeah. So would it be right to say that in that case the offer was to accept a Part 36 offer?
The offer was a Part 36
It
offer,
was.
and the claimant accepted it, so it was a defendant's offer.
Right, so defendant's offer, and that was accepted.
Correct, my Lord, yes.
So it was an integral part of the offer which was accepted, that it was a Part 36
Absolutely,
offer.
my Lord, yes.
That isn't the case here, is it?
Well, my Lord, no, that is, of course, part of the background, but no, there may be an issue about this, but no, it would appear that's not the case here, because the claimant declines the Part.
So this was not a Part 36. It was not. It was not a Part 36 offer.
Well, my Lord, there is. I'll come to this in a moment, but there is a Part 36 offer
Which was not
where
accepted.
the claimant says we are not accepting it because we are within the 36-14 period, and here is a consent order to address that issue. Now, my Lord, our primary case is that although they refer to not accepting it, what they are in fact doing is providing a mechanism to address 36-14, and they are themselves invoking Part 36 to bring the case to a conclusion. But my secondary case, and frankly, in my respectful submission, nothing actually turns on this, because we're as satisfied with our secondary case as our first. Our secondary case is, if we're wrong about that, then yes, there's no Part 36 acceptance. There is a separate offer and acceptance which follows it. But I should be clear that we do run both limbs of that argument. So, my Lord, within this case then, if I can just briefly identify to your Lordships the parts of this case that we say are material for your Lordship's consideration.
Yep.
So, your Lordships are well aware it's dealt with by my Lord Justice Newey at paragraph 12 that there's no bar to contracting out of the fixed cost regime. I simply provide that reference for your Lordship's assistance. At paragraph 17, the court identifies that an offer that contains terms as to cost departing from the provisions of Part 36 cannot be a Part 36 offer. And my Lord Justice Newey ties that in a few moments, therefore, to the fact that a Part 36 offer, to be compliant with Part 36, can only be offering fixed costs. And I'll come to that in just a moment, but that's the sort of foundational brick that he's laid for that later conclusion. We've already looked at paragraph 19, which deals with the fact of process of detailed assessment applying to resolving disputes within the fixed costs regime. We then have at paragraph 20 this dichotomy about Assessment and fixed costs. And so in the Solomon and Cromwell case, which has been referred to in this judgment, the Lord Justice Moore-Bick, dealing with early arguments about this sort of issue, identified that although he accepted that the then applicable fixed cost regime, which was a little different to the current one, does involve an assessment of some kind, particularly in relation to disbursements, I don't think that one could properly regard it as representing an assessment on the standard basis. And no doubt that's entirely correct, because part of those costs are simply not assessed on the standard basis. So there's an assessment, but he concluded it's not an assessment on the standard basis, or at least not of all of the costs anyway. Then in Broadhurst, the Lord Dyson explained that fixed costs and assessed costs are conceptually different, and his dictum is set out there. And my Lord, again, I can't, and I don't seek to go behind that, because of course if you're actually carrying out the process of assessing the profit cost by saying, well, what's reasonable for that task? What's reasonable for that task? You're going to reach a different outcome from the cost being fixed. The point I seek to make, and I hope I'm not flogging a horse whether it's dead or alive, but the point I seek to make is that the difference between the fact that there may need to be a process for resolving disputes and that the only identified process is detailed assessment, and the question within that detailed assessment of whether and to what extent the rules fix or don't fix some of the costs. And I make the point again by reference both to these sorts of cases, which we've seen mentioned above at paragraph 19, and not just disbursements, but for example, arguments that might arise as to the quantification of the fixed costs, or indeed whether fixed costs apply, as in this case, the whole argument about whether fixed costs apply arose in a detailed assessment, of course. But also, for example, the example I gave of fast-track trial costs, where there may be an assessment of all of the costs, but if the rules say part of the costs are fixed, part of the costs are fixed. So the fact you have a detailed assessment is a slightly different point from the fact that within that, if you're assessing costs as opposed to them being fixed, the two are different. You're going to come up with a different outcome.
You've more than made good the point that fixed costs may involve some element of assessment. But the question that we're involved in is construing, interpreting
Lord, yes.
what two firms of solicitors understood and intended in agreeing that the phrase be costs subject to detailed assessment. And in that regard, one has to take it as context that they are both aware of the law as represented by, set out in Solomon and Broadhurst, and that there is a difference between fixed costs and assessed costs.
My Lord, yes, but I would say that they also would be taken to be aware of the fact that the only process for resolving any dispute about costs, including a fixed cost case, is detailed assessment.
Was your offer was a Part 36 offer?
My Lord, yes.
Was it accepted?
My Lord, we say our primary case is yes, our secondary case is no. Which I appreciate is a less than ideal answer. So
where's the acceptance? Where do we see the acceptance? I'm sorry if I'm pulling you out of your carefully constructed lines of argument. But what do you say is the acceptance of your Part 36 offer?
It's the words which say our client is not hereby accepting the defendant's Part 36 offer. Those are the words which mean you accept it. It was accepted.
My Lord, I think I've indicated that I can appreciate the difficulties in that primary case. I'm content to proceed on the secondary case, that this is not an acceptance.
Well, before you abandon your primary case, because it may be relevant to understanding the strength of your argument overall, what is your case as to where we find the acceptance of the Part 36 offer?
Well, my Lord, if I can come to that letter which we have in the supplemental bundle, and perhaps this is the appropriate time to take your lordships to the documents. The letter of from the claimant solicitors is at page 39 of the supplemental bundle. It's dated the 16th of July. And my Lord, well, your lordships have and no doubt will read that, but the key parts are, of course, the
third and fourth paragraphs,
my Lord. So, our client is not hereby accepting the defendant's Part 36 offer. Part 36 offer has been made at a very late stage, well within the 21-day period in 36.13.4. In these circumstances, we consider an order is required to finalise matters. Now, I don't want to strain at the court's patience, but we do say that in context, what is being said there is that the offer is acceptable, but there is a procedural hurdle, which is 36.13.4, and that the claimant solicitors perceive that in light of that procedural hurdle, a consent order is required. And so therefore, our primary case is that whilst I acknowledge and do acknowledge the terms our client is not hereby accepting, if we take the whole letter, what the claimant is in fact saying is your offer is acceptable, but we need procedurally to come up with a consent order to put this to bed.
Before we leave the letter, I wonder whether you have any submissions on the 5th paragraph.
My Lord, yes. I recognise that what the claimant does here is indicates that if for any reason there's going to be a hearing, it reserves its position on costs. And of course it can do that. Of course there may have been different outcomes, which mean that there would have been a different cost outcome if it had reached that point. It's relatively standard, I think, for parties to reserve their position.
But that's completely inconsistent with them accepting the Part 36 offer.
Well, my Lord, no. In my submission, what they're doing is they're simply indicating that if for any reason, so for example, if for whatever reason the court was not content with the consent order, bearing in mind that they're only 3 days away from trial, and that, for example, there therefore has to be a hearing at trial, that may encompass costs that they weren't anticipating in their acceptance, and therefore at that position they would reserve their right to argue for a different outcome. But that's
You say, is your case that the 5th paragraph is consistent with your primary case, perhaps faintly pursued primary case, but nonetheless your primary case, which is that the claimant was accepting your offer?
My Lord, yes. Our primary case is that what is happening here, whilst I fully appreciate that this court will not readily construe words to mean something different than what they appear to mean on their face, but that when we take this collectively, what the claimant is doing here is saying your offer is perfectly acceptable, but for this problem with 3614, which means we think that we need to put in place a consent order, and therefore we are attaching a consent order to give effect, in essence, to the offer that we are accepting.
And they obviously, or at least they seem to think that they are accepting something, because in the second line of paragraph 5, to which my lord referred, they say they've now reached an agreement, whereas if this is just a counter-offer, having rejected the Part 36 offer, there would not be an agreement.
Well, my lord, again, I don't wish to take a point that should be corrected. What they're referring to in paragraph 5 is the fact that there was an agreement reached on a 70-30 liability split.
Oh, I see.
So in the conversation that preceded the Part 36 offer,
I see.
the representatives agreed a 70-30 split.
Okay.
Again,
So, leaving your primary case to one side for the moment, if we take this document at face value as indicating that they're not accepting your Part 36 offer, was the offer that they were then putting forward a Part 36 offer?
my lord, no.
Okay. So
It's not in Part 36 terms. It's the actual terms of the offer are to be found in the consent order, which for some reason is described as a draft judgment at page 41.
yeah. And you accepted this
We did, my lord, on that
with
second
one or two
position.
amendments which we needn't worry about.
With inconsequential amendments, my lord, yes.
So you were accepting a non-Part 36 offer,
My lord, yes.
right?
So, my lord, on that secondary position, then what we have here, again, in terms of the matrix, is a case which is plainly an ex-protocol fixed recoverable cost case. So it's plainly a case where, to use the dictum from Hislop, which I've not taken your lordships to because your lordships have indicated, Lord Justice Phillips has indicated that the court has well seen those and well understands the context that parties start and end with the expectation of fixed recoverable costs. So this is, the matrix is plainly a fixed recoverable cost case, absent any express exception applying. Nobody suggests at this point that any do, or the parties contracting out. And so we say in those circumstances, what's happening here is we are given a reason why our offer is not acceptable. Now that reason is not we want non-fixed costs. It's not stated to be that we want non-fixed costs. Indeed, even were it not for the reason that's given, we say simply coming back and saying, well, here's a consent order, cost to be subject to detailed assessment, doesn't necessarily carry within it the implication that the costs are non-fixed. That was the conclusion the court reached in Ho, that the reference to detailed assessment was not in the circumstances sufficient to displace the otherwise application of fixed costs. And for the reasons I hope I've given this court today, the fact that in a fixed cost case you say cost to be subject to detailed assessment if not agreed is just a fact. It is the procedural fact of life.
But Ho was a case in which the order was expressed as being in accordance with Part 36, Rule 13. Such cost to be subject to the detailed assessment if not agreed.
There were two.
But we've agreed, haven't we, that this wasn't a Part 36 offer and acceptance.
We have, my Lord. There were two aspects to Ho, as I hoped I'd indicated when we first dealt with it, which was firstly the question of whether the reference to 3613 in some way meant non-fixed cost, and the second was whether the specific inclusion of the term subject to detailed assessment meant non-fixed costs. And what the court held was, well, it was a Part 36 offer, so it must have intended fixed costs. And then it went on to consider the question of whether the words subject to detailed assessment were sufficient to then amount to an agreement to take it out of the fixed cost.
Yeah,
that would
in that, yeah, exactly. That was the interpretation of the phrase subject to detailed assessment if not agreed was in the context of it being a Part 36 deal.
My Lord, yes, but of course a fundamental part of the context here is the reason the claimant gives for the consent order, which is that reason is we've received a Part 36 offer, but 3614, on their understanding, indicates that we need a consent order. So the fundamental part of the matrix to this is that everybody must be taken firstly to understand that this is a fixed cost case, and their natural expectation must be you only get fixed costs. Secondly, that the defendant could only ever have been offering fixed costs in its offer because its offer was a Part 36 offer and could not, therefore, be construed consistent with Part 36 as being anything other than an offer for fixed costs. And the counter offer gives one reason only for that, which is by reference back to the Part 36 itself, which is that in fact we think a consent order is required.
Well, I think that's a slightly narrow reading of what's said, isn't it? And they're saying it's well within the 21 days referred to. So therefore the automatic consequences don't apply. That's the whole point.
My Lord, yes.
So at that point, it's, as it were, up for grabs. An order is required. We enclose an order. There's no suggestion there that what is being done is, as it were, replicating the Part 36 results, ignoring the fact that it was 21 days. It was within 21 days, and you have to read in quite a lot of words there to get the result you're asking for. Well, all they say is it's not automatic. So therefore an order is required, and this is what we propose.
My Lord, yes. So the effect of being within the 21 days is that there's no deemed order. You don't automatically get to a deemed order on acceptance. So you need an order, and the parties either have to agree or the court has to decide it.
And all that they said is, here's the order, will you sign it? And you did.
My Lord, we did. And that all that order provides is that the defendant do pay the claimant's costs, such costs to be subject to detailed assessment. Now, I come back to the core point that we make, which is that here, of course, what we say the court must be considering against the background is whether a reasonable person in knowledge of all of the relevant factual matrix here would objectively consider that that was sufficient to identify essentially a mutual intention to take this case out of fixed costs.
Well, here we've got an experienced district judge who looks at this and immediately thinks this is an order for standard basis costs to be detailed assessed. So certainly that indication of what these words means is pretty clear. The circuit judge agreed with that approach. Will this court take a different view? That's what we're now addressing.
My Lord, indeed. But of course, the district judge in forming that view, of course, that was the view he formed. But we are considering here the documentation. So he didn't hear any evidence or anything of that kind. He simply looked at this document and concluded what he considered was the objective construction of this. But we do say in doing that, he went wrong because he focused, and it's very clear in his judgment, he doesn't focus on anything other than the word subject of detailed assessment is not.
Well, that's the right starting point, isn't it?
Oh, of course it's the right starting point, my lord.
Are you entitled to look at parole evidence leading up to an agreement?
Well,
In Ho, you could see from the terms of the order, terms of the agreement, that it was acceptance of a Part 36. That was the context shown in the document. Here, you have a court order which, on the highest authority, I think it's, sorry, trying to find the name of the case. Sansuri, is it? Sanssouci?
Is that the Rangers case?
Yeah, was referred to there. You look at the terms of the orders first and foremost, don't you? And it's very dubious whether you can look at the negotiations between the parties leading to an order.
well, my lord, in relation to that, we would say, firstly, of course, so this is a consent order, so it's a contract. So I accept the general principles of contractual construction apply. The offer is made in the 16th of July 2018 letter, combined with the draft judgment that's attached to it. And, Lord, the context of that is set out itself in the 16th of July 2018 letter, which sets out the relevant context. The defendant's Part 36 offer has been made at a very late stage, well within the 21-day period. And in these circumstances, we consider an order is required to finalise matters. That's what they say. Now, even if I were forced to put that on one side, Lord, if we come then to the order itself,
Yes.
and I come back to this fundamental point, in a case where it is undoubtedly part of the general background, not evidence of subjective negotiations or anything of that kind, but part of the general background that this is a system of fixed costs which is intended to avoid satellite litigation, it's intended to avoid disputes about costs, it's intended that everybody within it starts and ends, the words used by Lord Justice Coulson, with the expectation that only fixed costs apply. In those circumstances, is simply the reference to the fact that the costs are to be subject to detailed assessment if not agreed. So in other words, if you don't agree the quantum of all of these costs, there will have to be a process of detailed assessment. That's all paragraph 2 is saying. If you can't agree the quantum of these costs, there will have to be a process to determine them. That process of detailed assessment. That would be right whether the costs are fixed or not. Because if there was a dispute as to any of the fixed costs, the only process in the rules, as the Court of Appeal accepted, albeit by way of agreement between the parties in Adelakan, as was evidenced by the Court of Appeal in the case of Cham, the only process for dealing with a dispute as to the quantification of the costs, in this case, even if fixed costs apply, is detailed assessment. So does the reference, there's no reference to standard basis, there's no reference to not fixed cost. It's simply that if we can't agree the costs, there'll have to be a process of assessment. Is that objectively sufficient against the background that everybody's starting and expecting it's only fixed costs that are going to apply to take that? And that, my Lord, I appreciate, my Lord, I was about to say, I know I'm not preaching to the converted, but I'm certainly preaching to the understanding. I'm well aware of that, my Lord. We say against that background, it is important that the judge focused on the reference to detailed assessment. And we say that doesn't come close to going far enough. And we do say it's an important point because the problem here is that this is exactly what shouldn't be happening. District judges should not be being taxed with arguments about whether the construction of agreement is that fixed costs do or don't apply. Because if it's not going to apply, just like with the exceptions that Lord Justice Briggs and Lord Justice Coulson has repeatedly identified under the fixed cost rules, if they're not going to apply, because of the importance of the rules, because of the importance of avoiding satellite litigation, because of the importance of the expectations, if it's going to not apply, you expect something very clear to say it's not going to apply. And simply saying if we can't agree the costs, there'll have to be a process, which is the only available process anyway, to resolve any issue about quantum, we say cannot come close to dealing with that.
Well, if you were drafting the order, what would you put?
Well, if I were for the claimant, and I appreciate hindsight's a wonderful thing, but if I were for the claimant and I wish for fixed costs not to apply, I would include...
I'm saying for the defendant. how would you have drafted it for the defendant to say that fixed costs applied?
Well, my lord, I would have simply said probably something along the lines of defendant due claimant's costs in accordance with CPR 45(3)A or something of that kind. So it would specifically identify the rule. But whether that's necessary is, of course, the question. My lord, nobody's suggesting that things couldn't have been done better.
The question for the court is to construe the order.
Yes, my lord, I accept that.
And courts are quite familiar with the concept of fixed costs and the context of cost to be subject to a detailed assessment. And the question for the court is, when it sees an order saying cost to be subject to detailed assessment, what does that mean?
Well, my lord, it is, but again, that requires appropriate weight to be given to the relevant background.
Of course.
And my lord, I fully appreciate, and again, the point will no doubt come in my direction from one direction or another. But my Lord Justice Males in the Adelakan case says if parties wishes to settle on terms that fixed costs will be payable, it's easy enough to say so. And
fixed costs are payable or not payable.
Are payable, it's easy enough to say so. And I fully accept that. I accept the point that a defendant in every case could make it absolutely clear that fixed costs are all that are payable.
Well,
But the question is, sorry, my lord.
to avoid satellite litigation and the clarity that you've asked this court to give, isn't it far better all round that it's made absolutely plain that parties should stipulate what the costs order is in express terms, and so if they wish there to be, if they agree to there being fixed costs, they should say so. If they wish there to be standard basis costs on a subject to detailed assessment, they should say so.
Well, my lord, I absolutely agree, subject to one qualification, if I may, which is that a fundamental part of this is that it is fixed costs unless something takes it out. And therefore, it is not a question of this is at large unless you agree it's fixed costs or unless you agree it's not fixed costs. It is fixed costs.
I think what is very dangerous is to say, I mean, I can understand in Ho, because there you have a Part 36 offer which is accepted, and everyone agrees it's a acceptance of a Part 36 offer, and therefore it must have been fixed costs, because otherwise it wouldn't have been a Part 36 offer. So in a sense it defines itself. But where you have a freestanding agreement where the parties are at liberty to agree the costs, it seems to me that to say that when parties say detailed assessment, costs subject to detailed assessment, they may be taken, for all the good reasons you've indicated, to mean something which most experienced civil practitioners would say doesn't mean fixed costs, but means the opposite. It seems to me that's asking for a whole load of trouble.
Well, my lord, again, if I may, to try and deal with a whole load of trouble point, because that is, again, it goes back to my opening, that is why we're here. We're not here really arguing about whether...
You're really asking us to say that in this context, the parties didn't mean what they said. They meant something else. And you say, for very good reason, they meant something else. It's really, it seems to me you're really saying that this is in a Lord Hoffman in ICS West Bromwich terms, that something has gone wrong with the language.
My lord, no, that's not what I'm inviting this court to do. What I'm inviting this court to say is that the parties did mean what they said, which is defendant to pay claimant's costs in an ex protocol case, which is therefore fixed costs. And the fact that if those parties can't agree those fixed costs, there has to be a process for resolving them, is neither here nor there to the question of whether the costs are fixed. And what I'm further inviting this court to say, and I hope I'm being fairly open about this, is to try and put a stop to this, because it's an ongoing problem. And in my respectful submission, the way to try and put a stop to this is to follow what this court has said in relation to the concept of exceptions or implied exceptions. The court will construe the exceptions to fixed cost rules as being narrow and limited in scope and only express, and it won't allow for implied exceptions because that's destructive of the nature of the fixed cost regime. So too here, we invite this court to say that if you don't want fixed costs, it is fixed costs unless, if I can put it that way, it's fixed costs unless. And if you don't want fixed costs, then it has to be something clear and express that takes it out of fixed costs, not simply a reference to the.
But how can we say, as a matter of law, that the parties cannot agree something by implication,
Well,
or by inference, or by some other form of construction? And how can we say that this agreement, unlike any other agreement, can only be done by the use of very specific express words?
Well, my lord, the answer to that, if I may say, is by this court placing the emphasis that the judges below failed to place on the necessary context, which is the points that I take from the cases of Hislop and Sharp and generally, as to what parties, when they're reaching the end of a case of this kind, should be understanding that they're going to get out of the case. And if you place the appropriate weight on that, then in order to displace that understanding that would otherwise be there, you would require some clear and express.
But what you're saying to us, as I understand it, is that this order should be read as though the word "fixed" was inserted before costs.
My lord, no, because my submission is that this order, where it says defend, if I may approach it from a slightly different angle, and I will, I promise, my lord, respond directly to the point your lordship's made to me. But if we approach this on the basis that at the end of a case which is otherwise subject to fixed costs, where the rules say plainly you're subject to fixed costs, you have an agreement between the parties, we'll pay you X amount in damages and we'll pay your costs, full stop. In that situation, the mere fact that the defendant agrees to pay the claimant's costs and doesn't specify fixed costs, in my respectful submission, could not remotely be properly construed, absent anything different, as being an agreement to pay non-fixed costs. And it's not because the parties haven't specified fixed costs or non-fixed costs. It's because the core matrix is that everybody at that point must be understanding that it's fixed costs that apply. And so you don't need to say, from the defendant's perspective, or indeed the claimant's perspective, and counterintuitive though it may sound, there are occasions when claimants want fixed costs rather than non-fixed costs. You get the odd case where, for example, these cases are meant to be low value. You get a case which turns out to be very high value, and a percentage of the very high value, even though it's an ex-protocol case.
This doesn't matter, does it?
My lord, no, but the fundamental point I'm making is that whether claimant or defendant, if you simply say at the end of a case of this type, we'll pay your costs.
Well, that would be a slightly different argument, possibly for another day.
My lord, in my respectful submission, that should follow because of the nature of the scheme and everything that we've said, that this court has said previously about what parties' expectations.
Well, wouldn't you accept this much? That it would be good practice for the party solicitors, where they intend that the cost should be fixed, to say so.
Oh, my lord, I would accept that it would be good practice on both sides. If you want them fixed, say so. If you want them non-fixed, say so.
Well, that's a pretty good starting point for
Lord,
guidance from this court, isn't it?
I think we would all agree with that. But the question is, what happens when you don't? And again, I do make the point.
Then you get into a dispute.
Then you get into a dispute, my lord. Absolutely.
Yes. And that's what we want to discourage, isn't it?
It is. So, my lord, I have no issue at all with this court. Not that it's for me to have an issue with anything this court does, but were I to be bold enough to try and do so, I would have no issue with this court.
Not to leave perhaps. Yeah. Okay.
With this court indicating that it would be in the interest of all if everybody was gave greater certainty to the outcome at the end of the case. But the problem is, as we've seen right back from Solomon, as we've seen through Adelaide, and as we've seen now, we have hundreds of thousands of these cases every year. They're dealt with by very junior fee earners. Perfection, unfortunately, is something that does not always happen. And the question is, in order to try and minimise satellite litigation, where does the court start, really?
Well, you start with the words, don't you? You must start with the words.
My lord, you start with the words.
And you interpret the words in the context. You started with the context.
Well, my lord, of course you start with the words, but if you start with the words, you end up in the context, or if you start with the context, you then construe the words against the context.
My lord and I have been reminded, in my lord's case, clearly in my case, vaguely, of a of a case that we heard together with Lord Justice Underhill. We remember it particularly because we were in the majority and he disagreed with us. I don't think he went to the Supreme Court.
Not that I'm aware of.
And in that case, we cite, and my Lord, given the lead judgment with which I agreed, cited from the decisions of the Supreme Court in Sans Souci and VRL Services. And I'm looking at paragraph 44 of my Lord's judgment. This case is called SDI and Rangers Limited, Rangers Football Limited, 2021 EWCA Civ 790. And it's really, to use your words, really a signpost to the judgment of the Supreme Court in Sans Souci, 2012, actually not Supreme Court, Privy Council, UKPC 6. And paragraph 44, my Lord's judgment in the Rangers case. And this is about interpretation of orders. In particular, principle 3, as summarised by Lord Clark, as summarised, subject by the Court of Appeal, drawing on Lord Clark in Sans Souci. The words of the order are to be given their natural and ordinary meaning, and are to be construed in their context, including the historical context, and with regard to the object of the order. That is the process with which we are concerned here, isn't it? We have an agreed order. We start with the words and interpret them in the context.
My Lord, absolutely. Nothing I'm seeking to say should be seen in any way to disagree with that. My Lord, of course, where I place the emphasis, of course, is firstly on what the natural meaning of those words is, and secondly, the context.
Well, the natural meaning of the words detailed assessment is detailed assessment.
The natural meaning of the words detailed assessment is a process, as we've seen, but Lord Justice Phillips took us to the definition, is a process for determining the amount of the costs. So that is a process that applies equally potentially to
Yes,
fixed
well,
cost base.
that's right, but I think practitioners would not, in the main, regard a reference to costs of detailed assessment as a reference to fixed costs, part of which might need to be detailed. There might be some form of assessment, whether summary or detailed, if the parties can't agree on some of the disbursements or something. We're talking about a wholly different thing.
And after all, the previous but one Master of the Rolls reminded us that fixed costs and assessed costs are conceptually different.
My Lord, they are, but again, the point that Lord Dyson was seeking to deal with in the Broadhurst case, he was seeking to deal with what the claimant in that case, defendant in that case, was seeking to say was a conflict in the rules, which was that in a case which had gone to judgment, where under Part 36 there are express benefits, bonuses to a claimant who beats their offer in judgment, one of which is an award of indemnity basis costs. The defendant was seeking to say an indemnity basis cost award is the same as fixed costs. And unsurprisingly, that got fairly short shrift because my Lord Dyson, in using the expression that the two are conceptually different, was making the point that if you go through the process of assessing the costs, so you're actually assessing the individual items of work done, whether it's on the standard or indemnity basis, that's going to lead to a different outcome to fixed costs. Of course it is. Of course it is. But my Lord, there's a distinction between that and the process for resolving disputes about costs, which for the reasons I've indicated, is well capable, indeed necessarily capable, because there's no other identified process of encompassing within it.
But I think
some of the costs are fixed.
You're looking at it, I think, through the wrong end of the telescope, as it were, because we start with the phrase assessed, detailed assessment. That's the phrase. You're saying that doesn't necessarily exclude fixed costs, because fixed costs can include an element of assessment.
Well, yes.
But if you look at the order in the context, if we're allowed to look at the letter,
Of course.
what the claimant was saying was, we're not going to accept the Part 36 offer because it's got too close to trial, and we've incurred costs on a scale which mean we think we were entitled to more. Consequently, we want a detailed assessment as set out in the order. Fifth paragraph, if we go to trial, we'll be asking for costs
at a higher level under 36.17.4.
Well, my lord, just in response...
Isn't that what they were doing?
Well,
Isn't that really the context of which we look at this order?
my lord, in my respectful submission, it's not. If we come to the context, the first point is in terms of lateness, in terms of the background. Now, if, for example, and they never expressed this, but if, for example, it had been part of the claimant's case, that we'd made Part 36 offers earlier, and the net effect of what you, the defendant, is now doing is you're accepting one or more of those Part 36 offers late. There's been an earlier offer on liability. And therefore, we have incurred costs after the end of the relevant period for a Part 36 offer, and that would be an argument which means we might not have to pay fixed costs. That could conceivably be an argument they advanced. They never express it, but it could have been an argument they advanced. If that was the case, then on this court's authority of Hislop, in fact, late acceptance of a Part 36 offer would not take them out of fixed costs. So that in and of itself would not have been a legally permissible justification to take them out of fixed costs. If they'd wanted, one of the perversities is, if they've wanted non-fixed cost for that sort of reason, what this court says in Hislop is, in fact, your only likely route through to that is one of the exceptions to fixed costs, which is 4529J, arguing that there are exceptional circumstances because of the lateness. You only get to 4529J in cases that fixed costs apply to. So they couldn't have got to that argument that you've delayed and you're acting late unless they accepted fixed costs applied and then on detailed assessment argued by reference to 4529J that there were exceptional circumstances.
Warming to my theme of the fifth paragraph of this letter,
Lord, yeah.
again subject to my Lord's questions to the extent to which we're entitled to look at it. If you look at the fourth and fifth paragraph together, isn't this what the claimant is saying? Because we've got so close to trial, we've incurred more costs than we will be compensated for under the fixed regime. Consequently, 13.4, liability for costs must be determined by the court unless the parties have agreed costs. That's what 13.4 says. Here's our order, which says just says detailed assessment. But if we have to go to court, we reserve the right to ask for more under 13.17.
Well, my lord, I would agree with that what they're doing is saying, this is our offer, we will take costs to be subject to detailed assessment, but if this has to go further, for example, the court doesn't accept the consent order or whatever, and we end up at trial, we reserve the right to ask for more. And whether they would have succeeded in doing so or not is another question. But if that offer is accepted and the alternative, the hypothesis doesn't arise, then in my submission, there's not anything in the offer that is being made to say, if this is accepted and if the hypothesis doesn't come about, we're expecting something other than fixed cost. And, sorry, my lord,
Get to the end of your sentence, because at the moment there's a brick missing from your carefully constructed argument, and I'm not clear where it's coming.
But perhaps before I build more bricks on top, perhaps I can find out which brick is missing.
It's where there's any acceptance by the claimant that the cost should be on a fixed cost basis as opposed to just detailed assessment.
My lord, I'm acutely aware of trying this court's patience because I come back to the point that I've made, which I know that this court has, whether it accepts it or not, which is that the fundamental point is that both claimant and defendant, and of course we're here dealing with the question of what somebody objectively construing this would consider this document means that these two parties agreed to. Both claimant and defendant should be taken to be approaching this on the basis that it is fixed cost.
Okay, I mean that is your case. Your case is as you've made it pretty clear. That's what.
My lord, yes, it is, and that is the fundamental point that we say the judges below failed to attach any weight to.
Despite that approach, they were entitled to at least ask you to agree to more.
Absolutely, Lord. And this.
The only question is when we read what they wrote. Well, it takes a straight fact question. When they wrote to you on the 16th of July, were they inviting you to agree to something other than fixed costs?
And this, of course, my lord, is where, if I haven't already, I get into what is almost certainly going to be impermissible reasoning, which is if we hypothesise what the response would have been if the claimant had said, we want non-fixed costs in terms, then at the very least they would have been asked to explain the basis on which they were asking for it. And as I say, if we follow the logic through, the logical basis on which they would have asked for it would have been a basis which would have meant the fixed cost would apply, subject to any exception that could, probably 4529J, that could be identified within that fixed cost regime and would be argued about on detailed assessment. So the likely outcome would have been, no, we say fixed costs apply, but if you want to argue our conduct means exceptional circumstances, then let's go off and have that argument.
All that means is what you're saying is your clients didn't understand or didn't pay attention to the offer.
Lord,
Appreciate.
Lord, I put it, for obvious reasons, slightly differently to that, which is that a reasonable observer objectively construing this would not take it that both parties should be taken to have known that this was to disapply.
That takes us straight back to looking at the terms of the order.
Yeah.
My Lord, it does. And
that's really where it comes from.
your Lordships will appreciate that I pursue the point, we say, for good reasons, and I hope with force, and therefore I engage with the argument as long as I can. But my Lord, I think your Lordships have my argument.
The strongest power to your elbow, as it were, comes from hope.
Yeah.
My Lord, it comes from hope, but it also comes again from the point that we have made that there is one of the reasons why there is a continuing problem here is because perfection is not always achieved with these things. There are so many of these cases nearly always settling without going to court, and perfection is not achieved. And of course, it would be great if it was. It would make my life quieter, but it would also make the court's life quieter if there weren't these arguments which occurred. It isn't always achieved, and so we have a position where, for example, parties might agree, we will pay your costs, or we will pay your costs subject to assessment, or something of that kind. And because there is a financial incentive on claimants' parts generally to take cases out of fixed costs where they can, then that leads to arguments that, that amounts to an agreement to take the case out of fixed costs. For reasons I've indicated, we say that is contrary to the general policy. But the more fundamental point, really, that we seek to grab is that what has followed from that is this misunderstanding that detailed assessment itself is incompatible with fixed costs, as opposed to the fact that if within the process of quantifying the costs you're assessing the costs, that is different to fixed costs. And I fully accept that. But the idea that a process for quantification of the costs per se is incompatible with the concept of fixed costs, we say is a misconception, which gives rise to a number of these arguments, and it's a misconception, we say, that is best dispelled.
But it isn't just a matter of incompatibility or not, as you would put it. It's a matter of how reasonable parties are going to construe educated in the law procedure are going to construe the use of that phrase in an order. It seems to me what you're really asking us to do is to give some super protection to your client insurers from the fact that their solicitors are not doing a proper job. Maybe because they are not, because they, as you put it, they are engaging solicitors who are not particularly sufficiently experienced or trained to ensure that the costs orders that they agree to reflect what their client's instructions are.
My Lord, unsurprisingly, I can't accept the full force of that. We would put the position in this way, which is that it has been perceived as being fundamental to the proper operation of the protocols and the fixed cost regimes, that the circumstances in which parties escape those are limited and are kept limited to express situations.
Yeah. So what you would like is a bulletproof form of wording.
Well, Lord, well, of course, I'm sure we'd all like a bulletproof form of wording.
Or that's inappropriate analogy. You'd like a clearer, bright line.
What I see.
Your hard pressed legal executives.
Well, my Lord, what I seek, and whilst they would no doubt take this with a pinch of salt if I say it, but which I say would be of benefit to both claimants and defendants, is the point clearly made, in essence, that fixed costs apply unless it is expressly and clearly provided that fixed costs don't apply. In other words, greater emphasis on the underlying context and expectation identified by this court previously as to the application of fixed costs, and that frankly more is required than simply indicating, for example, that if there's a dispute about those costs, they will go to detailed assessment.
Mr. Manley, thank you very much. What other points do you want to make?
My Lord, the only other point that I should address, your Lordships will be aware that there is a respondent's notice, and your Lordships may have seen my note in response to that respondent's notice, which it indicates our view that the respondent's notice does not add a great deal to the appeal, but we've responded out in an abundance of caution. I'm content to leave, of course, subject to your Lordship's direction.
Well, at the moment, I don't think we need to. We will be assisted by any further observations for you on that, unless there's anything you particularly want to add.
My Lord, no, I'm content to respond to it as necessary at your Lordship's direction. Okay. Unless there's anything further, Lords. Well, thank you very much.
So we're just going to rise for a couple of minutes and then take stock and then come back again. Thank you.
One thing that has occurred to me is I hadn't appreciated the potential importance of whether or not reference to detailed assessment means not fixed costs.
Slightly driven to it by
I appreciate that.
Justice Phillips.
I wonder if it might be useful to have copies of Neiman and Kirkland, which I appreciate isn't binding, but is Leonard saying if it's fixed costs, it's an application to determine those costs, right?
Yeah, quite how he equates that with what the Court of Appeal have said is another question.
Well, indeed. I suppose all I can say about that is that the Court of Appeal went tasked with determining it.
As I say, I suspect you may not need to go that far.
Maybe.
See what they say when they go back.
Yes. Yes, Mr. Latham.
My Lord, thank you. My Lords, I raise at this point at the outset, and I raise this with my learned friend, as your Lords took a moment away from the bench, that there may be a non-binding decision of Cost Judge Leonard in the Senior Courts Costs Office, which assists in respect of whether or not there needs to be a detailed assessment, by which I mean a notice of commencement served in accordance with Part 47, a bill of costs, points of dispute, replies, and a detailed assessment hearing in cases to which fixed costs apply. I apologise for not raising that point in my skeleton argument. I hadn't appreciated the potential importance of that question of procedure. What happens if there is a dispute about disbursements in a fixed costs case? In short, and I can provide copies during the course of any adjournment, but in short, Master Leonard took the view that where fixed costs apply, in the case he was dealing with was a Part 36 offer which was accepted, and so Part 3620 was engaged, then the appropriate procedure is not for a bill of costs, a notice of commencement and a detailed assessment, but rather an application to determine disbursements.
All right, well, we'll consider how we'll deal with that point when we know how long we're going to be. If we're going to finish before the adjournment, it'll be one thing, but if we go on after the adjournment, then you've got enough time to produce it.
I'm very grateful, my
Let's see how we go. Okay, Mr. Lyth.
My Lords, we've, during the course of my learned friend submission, trodden the ground. This is essentially a question of the words that were used in the consent order that was agreed by the parties and the construction of those words. Paragraph 26 of Hoe and Adelakun sets the four corners of the question of construction. But it might be useful for my Lords to consider that specifically. It's on page 14 of the authority bundle behind tab 2.
Yep.
And it's a very brief summary by my Lord Justice Newey on the principles of construction by reference to Wood and Capita. It involves the assessment of the objective meaning of the language, and by reference to Lord Hoffman's speech in the Investors' Compensation Scheme, ascertainment of the meaning which the document would convey to a reasonable person, having all the background knowledge which would reasonably have been available to the parties in the situation in which they were at the time of the contract. If I may just take my Lords to the Investors' Compensation Scheme case, which is behind tab 7 in the authorities bundle, very briefly, in order to address a question that my Lord Justice Phillips raised during the course of my learned friend submissions. Page 140 of the authorities bundle. I hope your Lordships will forgive me if I'm treading well-trodden ground. But at the top of page 140, this is the 5-stage test that Lord Hoffman articulated on the construction of agreements. And subparagraph 3, the law excludes from the admissible...
Sorry, which page? I'm sorry, which paragraph?
Page 140, my Lord.
Thank you. Yes?
The law excludes from the admissible background the previous negotiations of the parties and their declarations of subjective intent. So the fact that the defendant had made an offer which included, on any view, its Part 36 offer included an offer to pay fixed costs is not in any way determinative of what was subsequently agreed. As I say, that might be trite, but I think my Lord Phillips, the Lord Justice Phillips, forgive me, asked my Lord friend a question about whether parole evidence leading up to the agreement can be considered and to what extent. So that being the four corners of the law with regards to interpretation of the words of the contract, I turn my submission to the background knowledge. And I start, as I did in my skeleton argument, by making the point that both parties in this case are represented by solicitors who are specialists in this type of civil litigation. If I may, my Lords, I turn immediately to Broadhurst and Tam, which is in the authorities bundle at
Tab 4.
That's right, my Lord, thank you. And to paragraph 30, and I've set out in my skeleton argument, this is part of the background knowledge that these solicitors, and therefore by extension the party, should have. And it's the point that the starting point is that fixed costs and assessed costs are conceptually different. Fixed costs awarded whether or not they were incurred, and whether or not they reflect proportionate compensation for the work actually done. On the other hand, assessed costs do reflect the work actually done. And that is an important conceptual difference which was recognised by the Court of Appeal, this court, in Solomon. And if I may very briefly, my lords, take your lordships to the decision in Solomon, which is behind tab 9 and paragraph 19. And this in part goes some way to addressing the question of the procedure after fixed costs apply, as opposed to the procedure when costs to be assessed by a detailed assessment. It's at the bottom of page 160. And my lords will see that the this court in Solomon, recognising that fixed costs, it was section 2 of part 45 in that case, gave rise to a result which was different to what the result that would have been achieved on a detailed assessment and a line-by-line consideration of what was reasonable, expressly recognised that albeit when fixed costs apply, there may still be an assessment of some sort. And of course the recognition there was the disbursements, in the same way that under the current fixed cost regime there may still need to be an assessment of a type to determine disbursements which are not agreed. But in my submission, what's clear from that paragraph in Solomon is that it would be quite wrong to say that if one was discussing this matter with any cross-section of specialists in this area and one talked about a detailed assessment, one's mind would not go to the type of assessment that was recognised in Solomon, limited to 1 or 2 disbursements as part of an otherwise fixed regime. And one might say that that point could be enforced even further, given that under the current fixed cost regime, even some disbursements are fixed. So, for example, soft tissue medical reports are fixed cost, £180 plus VAT.
So, are you bringing us back to Hoe?
In the light of that?
Yes. Now we're coming back to a paragraph 12, paragraph to which my learned friend has already referred, and citing Solomon, this is page 9, reinforces the point that there is no bar in contracting out of fixed costs, and so it's well within parties' ability to do that. Excuse me. Turning to page 11 and paragraph 18. In fact, paragraph 17 first, if I may, my lord. Paragraph 17 sets out the authorities that provide that a Part 36 offer cannot contain terms which depart from Part 36 cost consequences. And so, again, it might be tried to say, and I make the point in my skeleton argument, that the defendant's offer was a Part 36 offer, there's no doubt about that. It included a provision to pay costs pursuant to Part 36, 20 by extension. The claimant's counter-offer, and in my respectful submission, on any view, it was a counter-offer, it was different terms.
Yeah,
it
was not a Part
it was
36
not
offer,
Part 36.
because it contained, on your case, terms of cost departing from Part 36.
Indeed, and so whereas a Part 36 offer has that starting point that my learned friend refers to, that fixed costs apply by operation of 3620, there's no starting point, in my respectful submission, when it comes to the terms of a consent order. In those circumstances, when one considers the terms of the offer made by the claimant, in this case, the counter-offer, in my respectful submission, it's abundantly clear that reference to assessed costs, costs subject to a detailed assessment, is a reference to costs payable outside of the fixed cost regime. And if I may take my lords at this point to CPR 44.3, in the white book it's page 1479.
Sorry, could you give me the page again?
Of course, my lord. 1479.
Thank you.
.31 provides in terms that where the court is to assess the amount of costs, whether by summary or detailed assessment, it will assess those costs on the standard basis or the indemnity basis. So where there is an assessment, it has to be on one of those two bases. And so that lends support to the proposition that where costs are fixed, there is no assessment. And it goes on to say that the court won't deny the case allow costs which have been unreasonably incurred or which are unreasonable in amount. But I also draw my lord's attention to subparagraph 4 of that rule, which provides that where a court makes an order about costs without indicating the basis upon which costs are to be assessed, or the court makes an order for costs to be assessed on a basis other than the standard or the indemnity basis, the costs will be assessed on the standard basis. And so practitioners in the field know that if they agree an order for costs and it doesn't use the words to be assessed on the standard basis, then 44.34 is engaged, and automatically those costs are to be assessed on the standard basis.
What it comes down to is that the order could not have said anything more than it did to provide for costs on a standard basis.
Yes, my lord, yes.
Also, it did not need to say anything more.
No.
And also, there's nothing in the order by way of reference to a Part 36 acceptance, or indeed in the contextual background, to say the parties didn't mean what they said.
Indeed. I can put it no better.
The parties and the court by endorsing you.
Indeed, and my lord made the point during the course of my learned friend submissions that this was viewed by an experienced regional cost judge in District Judge Rogers and by the circuit judge below, both of whom took the view that an order which provides for costs to be assessed by way of detailed assessment, perhaps in the context of 44.34.
Well, the submission presumably is that while when considering what those words would be meant by a reasonable man with the requisite knowledge, neither of those judges qualified.
That must be what flows from my learned friend submission. I appreciate he rightly doesn't put it in those terms. that must
Tendential terms.
There's all things only said by a judge of the Court of Appeal, in my experience. Yeah.
And so if we accept that the learned district judge and the learned circuit judge are reasonable, then their view carries weight. And in my submission, it ties in entirely with the claimant's view, and it's been the claimant's view from the 16th.
So you say that's clear even without looking at the context of the letter?
Yes, I do. And if I'm wrong about that, I then turn to the letter and I adopt, forgive me, Lord Justice Baker's analysis of that letter, which is that it says, in terms, if you don't sign this consent order, which is our counteroffer, it doesn't say our counteroffer, but if you don't sign the consent order, then we will proceed to the hearing, we will invite the court to enter judgment, and we'll invite the court to award additional costs.
And under 30,
under 3617,
617, which is potentially on a higher base indemnity.
Indeed,
Indemnity.
it would be. It would be.
Yeah.
Now, my lords have my skeleton, which makes reference to all of the other letters which are in the supplemental bundle. I'll be guided by my lords as to how much you'll be assisted by me taking you through them. But perhaps I could summarise them in this way. From the outset of the claim, from the moment that it fell off the portal and became an ex-portal case, the very first letter in the supplemental bundle is behind tab 2 and is from the 12th of January 17. And right at the outset, the claimant invited the defendant to consents of some form of alternative dispute resolution. And through those letters, and
we don't think this line is going to help us.
Particularly given that you took us to ICS and Lord Hoffman.
yes, well, I won't trouble you anymore
Which,
with this,
Yeah.
with those points. Turning back to Ho and Adelakun, and dealing, I hope, fairly briefly with what's left. The important distinction between that case and this case, and I think my lords have the point, is that that case involved the acceptance of a Part 36 offer, and so the automatic operation of Rule 3620, and this case does not. Excuse me. And when one looks at the importance of that and the conclusion that was drawn by this court in that case, it demonstrates that everything in that case pointed to that being an effective Part 36 offer, a Part 36 offer which was accepted within the relevant period and which, by operation of Rule 3620, fixed the costs. The only element of that case which pointed in the opposite direction towards an assessment of costs on the standard basis was the reference within the Part 36 offer to 3613 as opposed to 3620, and the reference to detailed assessment. And in my respectful submission, there is a great deal to be taken from my Lord Justice Mayall's conclusions in his few short paragraphs at the end of that judgment, page 19, going into page 20. On that occasion, it was my learned friend on the part of the claimant, and so I'm slightly adopting my learned friend's submissions on that occasion. But at paragraph 43, my lords will see that Lord Justice Mayall recognised the powerful argument that had been advanced that fixed costs and assessed costs are conceptually different, so that the words costs to be subject to detailed assessment if not agreed in the offer letter did indicate an intention to depart from the fixed cost regime, but on balance concluded in the end, because of the letter taken as a whole, which was clearly intended to be a Part 36 offer and give rise to Part 36 consequences, that the clear words of the letter were outweighed by those other features. And the difference between that case and this case is obvious. There is no weight of evidence that points toward fixed costs being agreed in this case. The only agreement is the agreement to pay assessed costs. And indeed, at the end of paragraph 43, my Lord Justice Mayall makes the point that it would be very easy to say.
You would perhaps invite us to endorse those words.
I would. And that avoids the doubt and the difficulty that my learned friend suggests is prevalent or might be prevalent if this court takes the view against the defendant. It's very clear, it's very easy for the parties to say the defendant will pay the claimant's fixed costs. Those are orders which are made up and down the country every day if there isn't a Part 36 offer and acceptance. And so that would put an end to the matter. I also make the point, albeit of course that wasn't the issue that was before this court in Ho. Paragraph 44, Lord Justice Mayall goes on to say that the claimant in that case had firmly taken his stand on the offer letter and acceptance, the Part 36 offer and acceptance, and the court wasn't tasked with determining what reference to costs on the standard basis might mean if it operated as a variance of the Part 36. But again, he makes the point, the parties who wish to settle in terms that fixed costs will be payable will be well advised to not agree to pay costs on the standard basis, because they are conceptually different and it's well known what those words mean. My lords, the other points are raised in my skeleton argument. I am not sure to what extent my lords might be assisted by me running through those other issues.
I just wanted to, wanted some help on something just to make sure that I'm not going wrong.
Of course.
On something. If you look at the bottom of page 1581 of the 2021 White Book, there's a practice direction about fixed costs.
Yes.
And at the bottom of that page, 210, it says if the parties agree the amount of the fixed recoverable costs and the only dispute is as to the payment of or amount of a disbursement, then proceedings should be issued under 4614.
Yes.
And 4614 is at 1620, which requires a Part 8 claim. And contemplates not a detailed assessment.
Yes.
Is that relevant, or am I barking up into the wrong
I
tree?
think not, my lord, with respect. The reason for that is you'll see it 1581.
Yeah.
Going back a little to 1580, at the bottom of that page, just before 2.1, these paragraphs deal with section 2 of part 45, which is the fixed cost regime, which previously applied
Okay, thank you.
pre-proceeding.
Right.
Thank you
There
very
would
much.
be a
That's very
Part
helpful.
8 application.
That's what I wanted to know. Thank you.
My lord, in which case, unless I can assist you any further, those are my submissions.
Stephen, do you want to say anything about the respondent's notice?
Oh, I'm grateful. Yes. The relevant page of respondent's notice, section 6, is on page 35, behind tab 3 of the bundle. Really similar to Malone and Friend, this was a respondent's notice filed out of an abundance of caution because the suggestion, let me rephrase that. Dealing with the first paragraph, the learned judge below, the circuit judge, said at paragraph 64 of her judgment that she accepted that the word assessed costs can refer to the fixed cost regime. And out of an abundance of caution, I simply made the point there that assessed costs being conceptually different, and the judge was clearly well versed in Broadhurst and Tam because she referred to it extensively in her judgment.
And that's your point about 44.3 as well.
That's my point about 44.3.
Yeah. So you've dealt with that.
I've dealt with that.
Yeah.
So far as 2 is concerned, again, the judge said at the beginning of her judgment that she'd taken into account all of the submissions. I made 5 points there that go to the background. Those points are raised in my skeleton argument together. Again, I'm not.
So there's nothing really additional.
Nothing additional.
Thank you.
Thank you.
Thank you.
Thank you very much, Mr. Latham. Mr. Manilew, on the rabbit out of the hat cost judgment, senior cost judge Lennon's, I think what we'll do is we'll ask Mr. Latham to produce a copy of it and 2 pages maximum of submissions on it, giving you a chance to reply. That seems the best way of dealing with that. But subject to that, what else do you want to say by way of reply now?
Well, my lord, endeavouring to keep the replies purely to points of reply.
Yes.
The first point, just to respond to Melody Friend's submission, that in the context where you're outside Part 36, there is no starting point. With the greatest respect, I'd invite this court not to accept that, even were it to be against us otherwise. And in particular, I come back and I'll do no more than highlight, because I've already highlighted the points, so I'll try and avoid the repetition.
Yeah.
But of course, the clear emphasis that this court, and in particular I rely on the Lord Justice Coulson's dicta at paragraph 50 of the Hislop case.
Okay. We haven't looked at Hislop, have we?
My Lord, we haven't.
Should we just have a look?
My
My
Lord,
part, it
it's
would just help to get
the
up.
relevant paragraph is on page
So we're
118
at
of your
tab
authorities.
6.
Lord, yes.
108, did you say?
The relevant paragraph is 118.
18.
I can take your lordship to the start of the case if it would help. But just
So 50, are we in 50?
50, my lord, yes,
Yeah.
50. And my lord,
This is your begin and end proceedings point.
This is my begin and end proceedings
all right.
point, and this is why I come back to the idea that the idea that there's no default starting point, whether you're under Part 36 or otherwise, is wrong, because the rules provide for the default starting point, and it's an important default starting point. You have to depart from it. And if you're departing from somewhere, you've got to have somewhere you're starting in order to depart from.
Thank you. Yes?
So, my lord, I make that point. So it's wrong to say that there's no starting point. The question, of course, is then did the parties depart from it?
Yeah.
My lord, in relation to the CPR 44.3 point, which I've to a certain extent already addressed, so just responding to it shortly. My lord, it was part of my submissions earlier to indicate that, of course, CPR 44.3 may have an application. Because if you find yourself, for example, assessing disbursements in a case where the costs were fixed, then what rubric do you apply to that assessment of disbursement? You can't simply pluck a test out of thin air. The test is the assessment test. Likewise, my lord, there are a range of cases where you have part fixed costs and part non-fixed costs. So the Broadhurst case is the classic example. The Broadhurst case was all about a claimant beating their own Part 36 offer. And therefore, from the end of the relevant period, they had non-fixed costs. What they didn't have was non-fixed costs for the whole case. They had non-fixed costs from the end of the relevant period of their offer. And so that claimant had a period for which they had fixed costs and a period for which they had non-fixed costs. And so you'd end up on assessment with the court looking at the rules and saying, what period are the costs fixed for? Well, that's up to that point. Are there any disbursements in that period that need to be assessed? Yes, we apply the test under 44.3 to those bits we're assessing. What period do they have non-fixed costs for? Well, that later period. What test do we apply to those? Well, the test under 44.3. So the test under 44.3 remains of relevance, but it is not inimical to the idea that as part of the assessment process, just as the example I gave your lordships with the fast-track trial costs, just because you actually have an order in a fast-track trial saying defendant pay claimant's costs on the standard basis to be subject to detailed assessment if not agreed, and that even has the standard basis bit in it, you'd still get to a point where the court would say yes, but actually looking under the rules tell me that actually this bit is fixed. And so you have an assessment, and question one in the assessment is, do the rules prescribe that any part of these costs we're looking at are fixed? If so, have the parties agreed otherwise? But none of that is inimical. So my learned friend's suggestion, and I think it was what was implicit in his argument, that if we look at 44.3, that shows that you can't have the concept of an assessment and fixed cost running side by side. My respectful submission doesn't work, because that's exactly what you can end up with.
No, but 44.3 and following just give one a guidance as to how one interprets the words in an order. That's what it's designed to do.
My lord, yes, and of course that comes back to my point, which is, and again, it's no part of my argument to suggest either District Judge Rogers or Honourable Judge Ingram are per se unreasonable. Of course not. Indeed, having appeared in front of Honourable Judge Ingram, she was extremely reasonable in dealing with the case. But my point is that what they have failed to do in reaching their conclusion is attach the necessary weight to the starting point that my learned friend has that does not exist. And, in particular, as my learned friend highlighted when addressing his respondent's notice, the district judge below acknowledged that assessed costs might mean one thing or the other, that assessed cost is not necessarily wholly inimical to the idea that the costs are fixed. And if that's right, what then is it, beyond the reference to assessment, that draws this case away from that starting point that fixed costs apply to the conclusion that, objectively construed, the parties here must be taken to have intended the exception to the rule. The exception to the rule. And so, my lord, that is... and in relation to that, my lord, I just make the point, again, my learned friend touched on, but then, for understandable reasons, slightly pulled away from the previous correspondence. But even if there was weight to be attached to this idea that the defendant may have been susceptible to a non-fixed costs position because of their conduct, which we don't accept. Your lordships only have a snapshot of the correspondence, and there's been no finding below against which I need to appeal. that my client's behaved unreasonably. But even if that were otherwise the case, the most likely outcome is that any departure from fixed costs under the rules would have been only a partial departure. So, for example, had my learned friend relied on, at trial, 3617, which is the bit they refer to in their letter, that would have been, we made an offer, it expired at a certain period, we've beaten that offer. You'd be in the Broadhurst scenario. You'd have part fixed costs, part non-fixed costs. If it was that our conduct in accepting the offer late, if that's what they said we'd done in effect, well, that would have A, run into the Hislop decision, which is that doesn't warrant a departure from fixed costs, but B, even if it had, would have amounted to an argument, well, you should have accepted our offer earlier, therefore we get non-fixed costs for part of the case, but fixed costs for the earlier part. If it had gone through 4529J exceptional circumstances, it would have been from this point onwards, when we gave you this information, you weren't playing the case fairly. Therefore, the court would have said, well, if you're right about that, claimant, you can have exceptional circumstances and disapply fixed costs from the X date onwards. There was no obvious reason why anybody in this case on the defendant's part would ever say, well, let's forget all about whether we even argue that. We'll just give you non-fixed costs for the whole case. For the whole case. And that's what the claimants say the defendants did here, just by agreeing to a term which said detailed assessment if we can't agree the costs. And that is, we say, an important part, because it goes to a point which was made by the Court of Appeal in the case of Solomon and Cromwell, which will be my final reference, if I may. If I can just take your lordships very briefly to that case. That case is in the authorities bundle at page 155. And your lordships have seen reference to that case earlier. And if I can just invite your lordships on to page 162, the judgment of Lord Justice Morbick. This was an early case based on an argument that the claimants had contracted out of fixed costs. And one of the difficulties in that case was that the old system of fixed costs rules and the old version of Part 36 provided that even in a fixed cost case, if a Part 36 offer was accepted, that led to an order for cost to be paid on the standard basis subject to detailed assessment if not agreed, which is a fairly firm indication it might be thought of something other than fixed costs, but the Court of Appeal rejected that argument. And part of its reasons for its rejection are at paragraph 25. And the first was the Part 36 point, which we've seen in Adelathan and elsewhere. And then the point that Lord Justice Morbick makes from between letters G and H onwards was that there was no reason to think that the issue that's now arisen was present to either party's mind at the time, and it's difficult to see why the defendant's insurers should be understood to, in that case they were the offeror, not the offeree, to have offered something for which the rules do not provide. And in this case, that's exactly, in essence, what we are said to have intended to accept by accepting this offer. We're intended to have accepted a complete disapplication of fixed costs for the entirety of this case, in the circumstances where, under the rules, it's difficult to see how the claimant, even if it made out its factual arguments about any of the points, could ever have achieved that end. And why should it be taken that that is what the defendant intended to do, in the absence of, we say, the necessary very clear words to say, fixed costs don't apply? My Lord, I won't address, unless your lordships think it will help, the respondent's notice. Your lordships do have a written reply to the respondent's notice, but as became clear in
well, I don't think there's any need for you to do that. Mr. Latham hasn't expounded the point, and
I think
unless there's anything else you want to say about it, I don't, for my part, think there's any need for you to reply on it.
My Lord, as I say, your lordships have my short written response, and I think it became clear that not a great deal, no disrespect at all to Mr. Latham, is added to the case by the respondent's notice. So unless there are issues arising from it that your lordships wish me to respond to.
Are you content to deal with the little case the way I suggested? Yes. You're content to deal with it? Yes. All right, well, thank you very much. Can I say we're extremely grateful to both of you for the clear way you've put forward your case. Both of you. I'm looking at Mr. Manley in particular because he's done most of the work this morning. Both your written submissions and your oral submissions, if I may say so, have been particularly clear. Thank you.
Thank you.
Thank you.
We're going to reserve judgment in this case. Could you, Mr. Latham, provide a copy of that authority you referred to
Of course.
today?
Yes.
And if I was to say any further note you wanted to add, further submissions by Friday,
Yes, that wouldn't cause me
Morning.
any difficulty, my lord.
and then, Mr. Malley, if you wanted to reply, would Monday morning be all right for you? Is it okay?
Lord,
Well,
Well, well,
yes.
good. What do you think?
It depends on what time on Friday.
Yeah, what would you suggest?
If it assists, my lords, I can be quicker than Friday. I
Okay.
could probably do that by tomorrow morning.
Okay, by tomorrow, thank you. By tomorrow morning, that's Wednesday morning.
Wednesday morning.
Then if we gave you the weekend, Mr. Malley, would
my
that be
lord,
all right?
again, I'm content until Friday.
Okay.
If that would assist, if my
All right.
friend can do it by then,
Well, we'll give it till Monday, Mr. Malley. Just
Your
yes,
lordship's very kind.
is that all right with you? Okay. So we're reserving judgment. In due course, our judgments will be sent out in the usual way, in draft, for you to consider and suggest any typographical corrections or any minor factual corrections. Not obviously an opportunity to re-argue the case. And then after that, after we've got your comments back, the judgment will be handed down in what's now the permanent way, remotely, and there's no need for you to attend. We'd be grateful if you would, however, agree a draft order and submit it with your corrections. If there are any issues on the order, we will resolve them in writing.
Thank you, Father.
So thank you both again very much.
Thank you.
Court prize.